earlier, right?
Yes. Ma'am, I affirm that nothing changed insofar.
Your evidence is that those changes, those handwritten changes on that copy were signed by you and you alone, right?
Yes, ma'am. That's why I wanted a withdrawal of the attack on the colleague who was Commissioner of Oaths, because there was an insinuation that he's a criminal.
Right. Now let's deal with your affidavit of the 28th of February 2023, page 482, Tsapo. So Advocate Mbofu suggested that this affidavit was flawed or defective in some way because it wasn't initialed by the commissioner on every page. Do you remember that?
Yes, ma'am.
So when he was asked to refer the committee to the law that makes this a requirement, he referred the committee to section or to regulation 4 subsection 1 of the regulations governing the administration of oaths or affirmation. Tsepo, put that up, please. Yes, that's the one. Let's go to the section that Advocate Mbofu referred the committee to. He referred the committee to regulation 4 subsection 1. Can you indulge me, please, Advocate Madonsela, and read regulation 4 subsection 1 into the record?
Sure.
Thank you, ma'am.
Just before you do that, before my apology, Advocate Madonsela, just before you do that, I have a hand. Advocate Mbofu.
No, I wanted to know if this witness is also being called as an expert in law. If she is, then she should be qualified so that we can then deal with her as such.
Thank you. The witness is being asked to read the document. Advocate Mayos?
Yes.
No, Chairperson. Sorry, Chair.
I'm with Advocate Mayos now. If you're raising a hand, I'll come back to you. If you raise a hand, I'll come back to you.
Yeah,
you've got to allow the flow of the meeting so that it's not you who must be listened to. Thank you.
Chair.
I'll come back to you. Advocate Mayosi?
Chair.
Chairperson, I'm objecting, yeah.
Advocate Mayosi?
Chair, the witness is being asked to read this section into the record. This is in direct response to Advocate Mbofu having brought this very section of the regulations to the attention of this committee and having relied upon it when he was asked specifically to show the committee what he was relying on.
Thank you. Advocate Mbofu?
Thank you, Chair. Yeah, no, that obviously is so. That's not the point I'm making. I think she's missing the point. The point I'm making is, you'll remember, Chair, that after lunch, I came back after I had been asked, I think by one member, 2 members and Advocate Mayosi, and I told them that I don't keep every section in my head. And I addressed you on the sections for you to note. That's it. I never addressed that to the witness or through the witness, because if I wanted to deal with the witness as a legal expert, then I could have canvassed it through the witness, which is what she's doing. That's exactly the point I was making. Legal argument will be made when the time comes for legal argument. But and there's nothing wrong if the witness is an expert in interpretation of statutes, in putting it. I'm simply saying that then she must be qualified as such so that we deal with her as an expert in the interpretation of statutes.
Thank you, Advocate Mbofu. I'm still not connecting with the expert argument. Advocate Mayosi, then I go to Advocate Madonsela.
Thank you, Chair. Also, I'm not asking the witness to interpret anything, but thank you, Chair. I'll proceed.
Just before you proceed, then, Advocate Madonsela.
Thank you, Chair. I thought this was my opportunity to
read the document, Tsepo.
To read the document.
Yes. Regulation 4 subsection 1, please, Advocate Madonsela.
Thank you. Regulation 4 subsection 1 says, below the deponent's signature or mark, the Commissioner of Oaths shall certify that the deponent has acknowledged that he knows and understands the contents of the declaration and shall state the manner, place, and date of taking the declaration.
Thank you. Thank you, Advocate Madonsela. Tsepo, now take us to the affidavit of the 28th of February to test that affidavit against what section 4 subsection 1 says. Go to the end, page 485. Now, what you've just read of regulation 4 subsection 1 is that what the Commissioner of Oaths must do is that he shall certify that the deponent, being you in this case of this affidavit, has acknowledged that she knows and understands the contents of the declaration, and that she shall state, the Commissioner that is, the manner, place, and date of taking the declaration. Has this been done by the Commissioner in relation to this affidavit? Advocate Madonsela?
Yes, ma'am.
Let's go back to the regulation, Tsepo. I'd like us not to just look at regulation 4 subsection 1. Can you also just read regulation 4 subsection 2 into the record, because it talks specifically to what a Commissioner of Oaths shall do in signing a declaration? Can you read those for us, please, Advocate Madonsela?
Thank you, Advocate. Subsection 2 says, the Commissioner of Oaths shall sign the declaration and print his full name and business address below his signature, and B, state his designation and the area for which he holds his appointment or the office held by him if he holds his appointment ex officio.
Thank you. Go back to the affidavit of the 28th of February, Tsepo, page 485. And my question again to you, Advocate Madonsela, has the Commissioner done what is required of him in terms of regulation 4 subsection 2?
Yes, ma'am, he did exactly that. As you can see, the stamp and also affirmation of his presence.
Right. In your evidence yesterday on this issue, you made mention of a case in the Western Cape High Court. You mentioned it during your evidence, but you couldn't elaborate on it. That is the case of Minister of Safety and Security and others versus Mohammed, right?
Yes, ma'am.
Share the citation for this case for the assistance of the committee is square brackets 2010 for all SA 538 brackets WCC, Western Cape High Court, a judgment that was delivered on the 30th of April 2010. Can you tell the committee, Mr. Advocate Madonsela, please, what the relevance of that case is to the issues raised by Advocate Mpofu in relation to your 28 February 2023 affidavit?
I think the essence of the Mohammed case is simply that an affidavit or a document so signed is not invalidated simply because the signature or not the signature, the initials of the Commissioner of Oaths are not on every page.
Thanks. I've taken the liberty of making a copy of the case. Tsepo, can you put it up, please? Yes. That's paragraph 26 of the case. And as Advocate Madonsela has alluded to, the issue that this paragraph was dealing with was the legal status of an affidavit where that affidavit does not contain the initials of the Commissioner of Oaths and on every page. And there I'm reading the bold and underlined, although it certainly is the practice for both the deponent and the commissioner to initial all pages of an affidavit on which their signatures do not appear, this practice is not a requirement for the validity of the affidavit. It is not required by the rules governing the administering of oaths and affirmations that are set out in the regulations promulgated under Section 10 of the Justices of the Peace and Commissioners of Oath Act 16 of 1963. Is that what you were referring to, Advocate Madonsela?
Certainly, and thank you for the opportunity to present it properly.
Now, the section, regulation 4 subsection 1 that was relied upon by Advocate Mpofu, does it say that a commissioner is required to sign, to initial every page of an affidavit that is presented to him?
No, ma'am, we just read it. It definitely does not say so.
Thank you. So just to move quickly along to the second issue that I said I was going to deal with today in my interaction with you, and that's the issue of the motion. So let's turn to the motion. Seppo, put it up, please. And I just want to point out two things at the outset, Advocate Madonsela, relating to the motion. Just for you to get a sense of the approach that the evidence leaders will follow relating to you and the motion, and the reasons for that approach. So two things. The first one is that engaging in it is the understanding of the evidence leaders that engaging in a competitive exercise between Advocate Mkhwebane's conduct and that of her predecessors, including yourself, doesn't form part of the mandate of this committee. So my interaction with you is not going to involve that. Do you understand that, Advocate Madonsela?
Thank you, ma'am. That was what I had been assured of.
Yes, the second point I'd just like to point out up front is that there's already evidence before this inquiry on the aspects of the motion that mention you in relation in particular to CIX and Vrede. So the fact that there's already evidence, coupled with the length of time that has passed, coupled also with the fact that you told the evidence leaders that you no longer have access to records. These issues are the reasons why the evidence leaders determined that it wasn't necessary to call you oral evidence. And the contents of the statement that you recently filed didn't change that determination on the part of the evidence leaders. Are you with me, Advocate Madonsela?
Certainly, ma'am, I am. Thank you.
Yeah, but you're here now, Advocate Madonsela, and be grateful for that. But for all these reasons that I've just asked to put up front, I'm going to be very brief with you when it comes to the motion. Are you with me again?
Yes, ma'am.
Yeah, so let's turn to the motion. Starting with charge 1, which is where Advocate Mkhwebane is alleged to have committed misconduct in relation to various things which it is said she did or failed to do in connection with the investigation, report, and litigation in the sub-CIX matter. You see that?
Yes, ma'am.
So go down to paragraphs 1.1 and 1.1.1. Yeah, 1.1.2 and 1.1.3, starting with 1.1.2. There, it is said that Advocate Mkhwebane, amongst other things, his conduct was objectionable because she materially broadened the scope of the investigation in the final report as compared to the provisional report, without giving notice thereof to any affected person and without furnishing any explanation. Therefore, do you see that?
Yes, ma'am.
And it is also said in the next paragraph, 1.1.3, that she materially altered the remedial action in the final report as compared to the provisional report on the instruction and or advice of the presidency and or the state security agency, and without giving notice and an opportunity to comment thereon to affected persons. You see that?
Yes, ma'am.
Now, the evidence that is already before this inquiry, and which you've now also confirmed in your affidavit, and I think this is fairly uncontentious, is that you left no approved or signed off provisional report when you left the PPSA in October 2016, right?
Yes, ma'am.
And the final report in this matter was issued on the 19th of June 2017, more than 18 months after the end of your term, right?
Yes, ma'am.
So the comparisons between the provisional and final reports that are referred to in these paragraphs, in these charges, these would be comparisons of provisional and final reports issued by Advocate Mkhwebane and not you, correct?
Yes, ma'am.
Chair. Okay. First,
Yes, Advocate Mbofu.
apart from the futile attempt to amend the charges, that cannot be put as a leading question, because once again, it's evidence from Advocate Mayosi, which is completely worthless unless if it's given under oath.
Thank you. Advocate Mayosi.
And subjected to cross-examination.
It's on the record, Chair. You can ask the questions differently. It is your evidence that you didn't issue a final report, correct?
Yes, ma'am. And I said so yesterday as well. It's just a confirmation.
And it's common cause on the record that Advocate Mkhwebane issued the final report in June 2017, correct?
Yes, ma'am.
You didn't issue a provisional report, as you stated in your evidence, and it's on the record that a provisional report was issued on the 20th of December 2016 by Advocate Mkhwebane, correct?
Yes, ma'am.
Thank you. So the comparisons are not in relation to reports issued by you, correct? It follows.
Yes, ma'am.
Thank you. Can we move?
Just pause, Advocate Mayosi. Advocate Mbofu.
Yeah, surely Advocate Mayosi must know that she can't do what she's doing. Surely. If you know.
What am I doing?
Sorry, yeah.
You can't put a conclusion to a witness, a legal conclusion that you seek to draw. You can argue it at the end. You can't put it to a witness. What's the witness supposed to say? Just a prop. This is not generations. So she must just say yes, yes, and to your evidence.
Chair, no legal conclusions were drawn here. These are factual conclusions based on the common cause evidence and based on the witness's confirmed evidence. Let's move on to the Vrede Dairy matter. Sepa, please put it up. It's the motion. It's the motion. And again, this is a charge of misconduct in which Ms. Mkhwebane is again alleged to have committed, to have done various things or to have failed doing various things in relation to the investigation, the report that was issued, and also the litigation, the ultimate or subsequent litigation in the Vrede Dairy matter. are you generally familiar with this charge, Advocate Madonsela?
Yes, ma'am.
It then proceeds to have subparagraphs, which, as do all the other charges in the motion, which describe what it is said Advocate Mkhwebane did or did not do in relation to the Vrede matter. In paragraph 4.4, it is said that Advocate Mkhwebane materially altered the remedial action proposed in the provisional report prepared by you before issuing the final report without providing any rational or proper explanation therefore. Do you see that?
Yes, ma'am.
Now, you testified yesterday that you didn't leave a provisional report in this matter, correct?
Yes, ma'am.
Is it also your evidence that you didn't leave a final report either in this matter?
Yes, ma'am, it is.
Sepa, please go to bundle A, page 1273. Bundle A, you've got it? Let's go down slowly. Go up. Yes, that's fine. Advocate Madonsela, this document, which is on the record, is a provision, says it is a provisional report on the investigation into complaints of maladministration against the Free State Department of Agriculture in respect of non-adherence to treasury prescripts and lack of financial control in the administration of the Vrede Dairy project. So in short, it suggests that it's a provisional report in relation to the Vrede Dairy project. Do you see that?
Yes, ma'am.
Go down, Sepo. Stop. So there at the top, there's a line that reads invisible oversight, provisional report by the public protector dated November 2014. Do you see that?
Yes, ma'am.
You were still the public protector in November 2014, correct?
Yes, I was.
Go to page 1351, Tsepo. The last page. Yeah, go down. Yeah. You see that this document obviously has your name in it as the public protector, and this, I think this is also part of the evidence before the committee. Advocate Cilias was part of this investigation. Do you see that?
Yes, ma'am.
It's an unsigned document. Are you able to tell the committee at all what the status of this unsigned provisional report is?
It was not a provisional report in the status of a provisional report of the pub protector. In other words, it had neither been quality assured by the quality assurance team, nor signed by me. When you see those initials appearing, all draft documents of the pub protector have that, although we had advised team members to stamp draft on documents, but it was a new practice. So you'll find every draft report, no matter how rudimentary it is, it would have the initials of the pub protector and the investigators that are working on it.
Was this, I mean, you've testified that you never left a provisional report by the time your tenure ended. It's correct, is it, that you never signed off on this report?
Certainly. And my evidence yesterday, you will recall, if you may, ma'am, was that I then asked Mr. Samuel to take over this investigation. And he certainly went there after these elevations had been prepared.
So yesterday, Advocate Mpofu, I think in relation to this issue, asked you a question to the effect that it would be illogical to then conclude that you had left a provisional report behind, to which you said that it would be untrue that this was so. Is that your evidence?
It still is, ma'am.
It would not be true, I think you said. You struggled with his use of the term illogical. You preferred it would not be true. Is that right?
I did, ma'am, because it depends on the context. If the facts appear to logically connect, you would arrive at a particular answer. It's not illogical on what appears to be facts. And then, of course, if later you realize that what appeared to be facts are not facts, then it just becomes untrue.
So if a representation or a statement is made in an affidavit or anywhere to the effect that this November 2014 report was a provisional report issued by you, would that be false or would that be true?
That would be definitely false. A provisional report is a signed document by the public protector.
Okay. I don't have any further questions for Advocate Madonsela, Chair. Thank you, Advocate Madonsela.
Thank you, ma'am.
Thank you, Advocate Mayosi. You would have started at just 9:15, and you're done now on your part. Thank you. It will now be an opportunity to turn to members, for members to interact with the witness. If they have any questions they want to raise with the witness. So I'm now going to open for that opportunity. And I will start inviting and noting members that wish to do so. I start with Honorable Milam as the first member. Followed by Honorable Begizwe Ngosi. Are there any other members on the virtual platform that wish to interact or ask questions with Honorable Madonsela? Because I seem to have been done here. Okay. Honorable Zungula, you will be next. And those will be the last hands on the virtual platform. Let's start in that way. Honorable Milam.
Thank you, Chairperson, and good morning to everybody. Advocate Madonsela, good morning to you.
Good morning, sir.
Advocate, could you tell me, you indicated yesterday that some of your reports were taken on review. Is that correct? Did I understand you correctly?
It is correct, Honorable Myla.
Now,
although I was never involved in that process.
can I ask, you said that you were disappointed by the outcomes, but what did you do when those reports were taken on review? What action did you take?
Well, on the one case that was taken on review when I was still public protector, it might be too or soon, when they were taken in review, we defended the case, and when we lost, we reflected on the outcome. For example, in the SABC manner, we reflected on the outcome and we decided to take it further to the SCA.
Okay. And when it went to the SCA, what was the outcome there?
At the SCA, we won the case. And that's why we got the precedent from the SABC manner, from the SABC case that said the public protector's decision has legal force. Of course, it didn't specifically say at that stage it had a binding effect, but it meant the same thing. We did the same with the Nkandla judgment, and with the Nkandla judgment, it was decided in our favor upfront.
Now, let me ask you this. You alluded to it, but let me ask you straight up. In any of those reviews or any matters while you were the public protector, were you found by a court to be ignorant of the law?
Not to my knowledge, sir.
Were you found to have misled the court or in any way submitted false information or infactual or unfactual, I'm not sure what the correct word is, information?
Definitely no on that one. Again, not to my knowledge.
And were your investigation processes at any point questioned by the court?
Not to my knowledge, sir, although there is a case that was brought in yesterday by Advocate Mpofu, where a judge in the High Court questioned my reasoning.
Okay, so questioning your reasoning versus questioning your processes, that's a different ball game, isn't it?
To my understanding, it is, sir.
Thank you, Chairperson. I have nothing further.
Thank you, Honorable Mailam, for those questions. I now turn to Honorable Becky Zwengos.
Good morning, Chair, and good morning to Advocate Madonsela.
Good morning, Honorable Nkosi. Good morning, sir.
In your tenure as the public protector of the Republic, did you apply the provisions of the Constitution and the law applicable to your office and other related law in respect of cases that you receive?
I did so, to the best of my knowledge and ability, sir.
In doing so, do you think that you applied your knowledge and your experience in the execution of your responsibilities?
I did so. Say that would be my understanding, sir.
Would you say that the application of the law constitutes your strength? And are there any weaknesses in that regard?
Will you repeat the question, sir?
Would you say the application of the law, based on your experience, constitutes your strength?
I would say it is my greatest strength, and that was complemented by the Bar Council, the Law Society, and the Deputy Judge President of the High Court of the Gauteng, Northern Gauteng High Court when I was awarded the Truth and Justice Award by the Law Society. And that is just generally what I was praised for, because, and I do know that that is my strength, because I don't just take advice from my team. We debated sometimes until the early hours of the morning. I also would not take advice from counsel. I would indicate to counsel what I think should be the approach. And then we would obviously then deliberate accordingly.
Okay, thank you. On your leadership, when you joined the PPSA, would you say that you moved the institution from what it was to a greater level or to a higher level?
My view is that I did, but I didn't do it alone. Firstly, as I said, say, in my affidavit, I inherited an institution that was rooted on grounding. I know the media often says differently, but every time the media says that, I say that if there were no fundamentals that had been built by my two predecessors, I would have not been able to take the institution to the next level. So it was a process of building on the shoulders of giants and working with a marvelous team to learn and grow together.
Would you say that the standard operation procedures that you introduced enhance the work of the public protector?
Certainly. Yes, sir. This has been even recognized by Yale University. If you Google this, there is a whole podcast and transcript where Yale University tried to document what we did during my time, which was to build on the systems that my predecessors started, both at the level of general administration, but more so on case management, from triaging to report writing and managing stakeholders and the media. And to top it, then I did prepare that standard operating protocol, which was quality assured with the team, think tanked with the team before I signed off.
Did this assist in proper case management of the complaints, and was it effective?
The case management and complaints was incrementally better. I would say it became a poly exercise. As a mountain climber, I would use that exercise, that it was not...
Sorry, it became what exercise? Advocate Madonsela?
Poly, that's it. Oh, sorry, say it's a Tanzanian
Oh, okay.
We're not...
about climbing a mountain one step at a time. I don't say that we summited the highest peak, but I can confirm without any fear of contradiction that we summited quite a number of peaks on the way towards the highest peak.
Would you say that in executing your responsibilities, you did so without fear or favor to any person, be it a Bheki Nkosi or a Gogo Dlamini or Mkhulu Kunene?
Absolutely, sir. As a result, there were times when we stood alone as a team, but we stood together, which was great.
Okay. My last question. When you left the institution, did you leave an institution that Bheki Nkosi would be able to inherit and run with? And would you be proud of an institution that you left?
Absolutely, sir. I would say that I left an institution that would make my successor have it easier than I did. But I also want to say that my predecessors made it easier for me than it was for them. And we had systems for case management. It was just the electronic version that we had to impair, because it was not of the capacity that could contain the caseload that we had started to inherit after the Scorpions were impaired. I also left policies that dealt with matters such as procurement, etc. But also, in addition to the institution, I personally conducted training together with other team members. We regularly conducted training on investigations, particularly to empower provinces, because before my time, they didn't do complex investigations. They only did inquiries.
Thanks, Chairperson.
Thank you, Honorable Ngosi. I now recognize Honorable Zungula.
Thank you, Chair. Greetings to yourself, members of the committee. Morning, Ms. Madonsela.
Greetings, Honorable Zungula.
I think let me start with the CX report. Would you agree that one of the contributing factors in the lack of appetite to recover the money by government was an attempt to protect the economy in line with the mandate of Treasury and the Reserve Bank?
Certainly, sir, I would agree that the argument had been that if we did collect the money, there would be a run on the bank. From a run on the bank, there would be a run on the rand, and a run on the country would be a run on the economy. And therefore, not that the money shouldn't be collected, but the feeling was that given the fact that it was different shareholders that had invested in the bank at that time, and we were now trying to collect years later, when new shareholders would now have to pay for it from that bank. And the bank concerned had even been bought by an international bank.
Okay, so in that sense, money that belongs to Gogo Dlamini would not be recovered because of that particular mandate. Now, would you say it's unreasonable for the mandate to be reviewed to protect Gogo Dlamini?
I would say it's unreasonable to review the mandate. Will you please repeat that question, sir? I did not quite understand.
So I'm saying that in line with your answer now, which effectively means that money belonging to Gogo Dlamini cannot be recovered from ABSA because of the mandate. Now, would it be unfair or unreasonable to review the mandate to make sure that Gogo Dlamini is protected?
So whose mandate?
The mandate of the Reserve Bank.
Reviewed here. You mean the lending mandate of the bank?
No. In my first question, I said one of the contributing factors in the lack of appetite was the mandate was to protect the economy in line with the mandate of Treasury and the Reserve Bank. And you said you agree with that, and you spelled out other issues. Now, the question I'm asking that in light of your answer, would it be unreasonable to review that particular mandate, the mandate of Treasury and the Reserve Bank, in order to protect a Gogo Dlamini?
So the mandate I spoke about was the mandate on regulating banks and lending. It's an institution with multiple mandates, but you do understand, say, that this investigation was, as indicated in the transcript of my interview with Chris Stolz, just looking at collecting your debt. So reviewing the mandate of the bank in terms of its lending practices and debt collection would definitely not be unreasonable, sir. Because that would be a logical connection with the wrong, because a remedy corrects a wrong. And as a public protector, we used to talk about righting the wrongs of the state.
Thank you. So I'm glad that we agree that it is not unreasonable to review that mandate to make sure that Gogo Dlamini is protected. Now, the investigation took more than 5 years. Is it something that is fair on the complainant that, the investigation and the issuing of the report takes so long?
It wasn't fair on the complainant, but it was reasonable. If you're talking about the real complainant, which is Advocate Paul Hoffman, he understood my constraints, because when I decided to buck the trend and undertake an investigation, it was clear that we were hugely under-resourced. And of course, I would have to fit it in together with the rest of my duties. And then, of course, Advocate Paul Hoffman was not happy with the delay, but he understood. And Michael Audley, who had triggered this investigation, was given the same explanation when I finally met him in September 2015.
Okay. Would you say the investigation was not prioritized like other investigations?
Repeat your question, sir. Sorry.
Would you say the investigation was prioritized or was not prioritized like other investigations?
It was far more prioritized than other investigations. If you are going to talk about my time, given the fact that I did not investigate, that was laid in evidence yesterday. You will see how many people I personally interviewed. It is again in the report, from the president of the time, President Begum. Chris Stolz can talk to you about how hard we tried to pin down the interview with him. And I took my time when I was in London for a different event to make sure that I arranged to meet Michael Audley. So definitely, but the approach at the Public Protector was twofold. Every investigation matters, but bread and butter issues matter most.
Okay. Why did you only work with a trainee and a young investigator in what you describe as a complicated investigation?
So, as I explained yesterday, this matter was rejected, and I did not want to burden my team that had used our triaging tools to say this investigation should not be done because it's a cold case. We didn't exist when the lending took place. The trail would be cold by now. And the possibility of recovering the money is next to zero. And this is taking into account that this matter had been the subject of an investigation by Heath and an investigation by Justice Dennis Davis, who both advised government against trying to recover. So the only reason, say, that I proceeded was because Paul Hoffman convinced me with the documentation that he heard, preliminary of course, but the money could be recovered through some kind of mediation and conciliation process. And that was the process under which I undertook this matter. And this is the process that I tried to pursue. You will see in my interview with Judge Bertelsmann, he himself admits that it is more of a moral issue than it is a legal issue when it comes to recoverability of the debt. And of course, at that stage, we didn't have the evidence of Chris Souls, which shifted the picture a little bit. So it is not true what you're saying with due respect, that it was not prioritized.
Okay. My question was, you were working with a trainee and a young investigator in what you describe as a complicated investigation, whereas one would presume that in light of a complicated investigation, you would want to utilize the best experienced and capable investigators. Is that not? Is that correct?
Yes, sir. I would have done so if I believed that I could not handle the complexity. I could work with others if I thought that there were some investigators that didn't have a huge backlog. Already, the team was struggling with a backlog. Statistics from the Public Protector are available that will show that we shifted just about the same number of investigations as my successor, if not more. If you look at per capita, if you look at number of investigations shifted, number of investigators at the time. And I would like to tender those statistics, and I would like to ask the investigators, the evidence leaders to kindly request the Public Protector to submit today a 25-year report on statistics. So I couldn't withdraw any investigator from a matter that they were already handling.
In 7.6e of your affidavit, you mentioned that the SSA was never involved in the investigation, yet you interviewed Mr. Billy Masetla from the SSA. Now, are you not misleading the committee by saying the SSA was never involved, yet you interviewed Mr. Billy Masetla from the SSA?
No, sir, I am not misleading the committee. When Mr. Masetla was interviewed, he was no longer with the SSA. He was interviewed, as I said in my evidence yesterday, that he was interviewed purely because he had been the one asked as the head of the predecessor of the State Security Agency to issue the contract, to be the contract owner of the original contract, which the contract, by the way, was not about what this investigation ended up being about. So I did interview Mr. Masetla just to understand, as the person who had issued the contract, number one, is it true that the money was not collected? Number two, why was it not collected? Number three, who made that decision? And we got the answers to all of that.
So you interviewed him in his former capacity or capacity of a person from the SSA?
Exactly, in the same way that you're interviewing me right now, sir, purely as somebody who has institutional memory.
Okay, so it's a different point. However, why did you not record the meeting with him?
As far as I know, it was recorded. I'm told that the record seems to be missing, as many recordings on this matter seem to be missing, including Michael Ortley's. But as far as I know, it was recorded because that was part of our standard operating procedures. But I do have my handwritten notes of that meeting, which I can submit to this committee.
Did it go missing during your term or after your term?
I don't know when did it go missing, because I was just informed when the evidence leaders were looking for information from me that Mr. Masetla's testimony is missing.
Okay. Talking about you recording or not recording your meetings.
It will be your last question.
I'm almost there, Chair. I'm about to wrap up.
Sure.
Did you record the tea that you had with Premier Makhashule?
No, I didn't, because I never recorded events that were not interviews. But every event that occurred in my office was recorded. So if you go to my office right now, or my former office right now, and you request my diary, which was left there, it would record that Mr. Makhashule came in, and it would record that he left. I didn't record the meeting because he said he had come to me for a cup of tea.
Okay. In 7.6b, you state that the tone, scope, findings, and remedial actions of the final CX report differed materially from your draft. Now, in light of new evidence that would have come up, would you expect that the report would have stayed the same?
No, I wouldn't expect it to stay the same. In fact, all I was indicating was that it has nothing to do with what I heard and what I would have heard. That's all. And I wasn't making a judgment on the fact that it changed.
Okay, last question, Chair, is that in your draft report, one of the remedial actions was to introduce regulation to prevent reoccurrence of the CX scandal. Did you support this remedial action?
Of course. I would have supported it if I had finalized the report, to the extent that it would be talking to lending. What I explained, Honorable Zungula, yesterday is what is in the standard operating protocol. You decide what happened, what should have happened. Is there a discrepancy between what happened and what should have happened? If so, shall we call it improper conduct? And if so, who was harmed? And how do we place them as close as possible to where they would have been but for the harm? We also would then look at, is there a systemic problem in this regard? So I would definitely support remedial action that was talking to future lending practices and debt collection, because this is what this investigation was all about.
Thank you. Thank you, Honorable Zungula and Advocate Madonsela. I now recognize Honorable Holomisa.
Thank you, Chairperson, colleagues, and our witness, Ms. Thuli. There are two questions. Yes. First question is, how did you deal with campaigns to discredit you and your staff by the ruling party during the Nkandla debacle? The second question is, Are you not surprised, right, Laura? Are you not suspicious that now you get praises from the same party members who insulted you when you were doing the Nkandla report and the state capture report and called you names such as spy, agents of American, as well as, there were a lot, but the opposition parties stood up and defended yourself. That's my question, or two questions. Those are my two questions.
Thank you. Just wait, Advocate Madonsela. Thank you, Honorable Olamisa, for those two questions. Over to you, Advocate Madonsela.
Thank you, Honorable Olamisa. Just firstly, thank you for the support that you unwaveringly provided for the team as it did its best to pursue its constitutional mandate and the truth and justice. I will start with your second question, saying, I'm not surprised that I get praised because we all deal with life based on the new information that we have. At any given stage in life, we act according to what we know, what we think, and how we feel. That's what neuroscience tells us. And I hold no grudges against anybody who dealt with me in any particular way at any given stage. They did so in terms of what they thought was good for them, for their party, and for the country at the time. And the fact that we differ about what we think is good for the country at any given stage does not mean we should always differ. When we have persuaded each other to see a picture that is beyond my paradigm and your paradigm, there's room for some kind of dialectical change. So I'm very happy about the changes that I see because they give me hope for our democracy. They give me hope for the country. And yesterday I worked until very late on the expropriation bill. So when I see people changing with new information, I think that we can find each other on seemingly intractable issues, such as the expropriation bill. It's 8 years since the African demands and 110 since 1913. So thank you for that. But on how did I deal with people who disagreed with me? Well, I would go to them. You will recall, say, that I would organize meetings with all of the parties in one room to indicate how we do business and why we do things. We would explain the procedure we follow with intake and assessments. For example, they would think I just sit in a little corner and decide what to investigate. Would explain them that there's a whole system of intake assessment, and all of the cases are sent to members of the team to approve or disagree with the intake and assessment team's decision. And it really worked because often, if I'm not wrong, we would issue joint statements with the governing party because it was big. We would meet with them. But one thing for sure, I always made sure that I brought my team in meetings with stakeholders so that they understood that I may be the professional who is appointed to lead the team, but I'm not necessarily the one with the brains and expertise to find all the answers. I rely on the thinking in the group, but ultimately everything that I sign is what I believe is the truth and legally sound decision to make. So that's all I can say to you, Honorable Holomisa, and thank you for your questions, sir.
Thank you, Advocate Madonsela and Honorable Holomisa. We will take a 10-minute tea break and be back after 10 minutes. Thank you. We pause.
Recording stopped.